We now wrap up part 3 of the course with a brief look at causation in the law. This is obviously not a law class, it's a basic critical thinking class, but this legal conception of cause is something interesting and perhaps worth knowing. So in law, at least certain parts of the law, causation is typically a matter of the connection between an action and a harm. So from a legal standpoint, only if an action causes harm or contributes to the cause of harm can a person be said to be responsible for that harm. So in civil law, it's a necessary condition of tort liability that a person's actions cause the harm in question. Because if the person did not cause the harm, then they would not have, liability. If one did not do it, then one would not be liable. Now, in the case of criminal liability, it's sometimes a necessary condition for some types of criminal liability, but not all of them. Now, in the law, because they like to use Latin, because it's cool, it's known as a conditio sine qua non, which is translated roughly a condition without which nothing. And that's kind of the broadest definition of a cause. It's sometimes also known as a but-for cause. That's to say that, effect Y would have not happened but for cause X having happened. For example, if the food had not been poisoned, then Sally would not have died. Now, in general, stepping outside the law, I suppose, it'd be silly to punish a person for causing a harm, for doing something, when that would have happened without them doing, anything. So what we need to do is establish that in the case of legal concern, the role of the person in that effect. Now, naturally, the sense of a cause can have effects that go on indefinitely. I mean, a good fictional example of this is time travel. When people and fictional characters talk about time traveling to fix things, they typically go for, say, like the immediate thing, but people do consider possibilities of going back even further in time to address them. To use an example, often when people talk about time travel, they often talk about killing Hitler. And so one could travel back in time and, kill Hitler, but one could also travel back in time, not kill Hitler, but interfere with whatever it is that led to Hitler's parents meeting. That way, they prevent, World War II. And so in a sense, you could say that the events that led to Hitler's parents meeting did cause World War II, because it ended up, giving rise to Hitler, which gave rise to World War II. Now, in the law, of course, even though people often see the law as like just being a matter of what people who have, the power to influence the legal system, essentially this is how, and again, very roughly put, how legal causal reasoning works. And it's often presented in terms of what's called a proximate cause. Because we could take the causal chain back, quite a ways. And so typically in legal reasoning, they put pretty severe restrictions on the sine qua non, a condition without which nothing, type of reasoning. And so a sine qua non cause, it's a matter of fact, a legal proximate cause is a combination of fact and decision or policy. And so, not surprisingly, what we consider like a legal cause is hopefully a matter of fact, but also, of course, there is a conscious decision on the part of the lawmakers to consider certain things to be, say, relevant causes and not relevant. And this can be done for a variety of reasons, some good, some bad. So deciding what causes are important or significant does require a legal decision or policy. Probably the most famous piece on this was written by H.L.A. Hart and A.M. Honor, whose name I'm probably horribly pronouncing, they wrote a famous essay on causation in the law, trying to show that, as odd as it sounds, common sense can guide the necessary decisions about cause and effect. So they make the case that for a person to be legally responsible for harm, we must be able to trace the harm caused back to that person's actions, which seems quite reasonable. For example, think of like wildfires, fires that break out in California, and suppose you could trace the start of a fire to someone carelessly tossing a lit cigarette into some bushes by the roadside that ends up igniting them and spreading quite a ways. Now, when considering the legal responsibility, various features and factors intervening would be considered that might mitigate responsibility. Others might not. For example, the dry conditions of the bush, the fact that wind came blowing through and fanned the fire, would not mitigate responsibility. Like if the bush had not been dry and the wind had not blown, then there would not have been a fire. But of course, the person, we might say morally and perhaps also legally, the person would be accountable for that. They don't get off the hook by saying, well, if the bush hadn't been dried, it wouldn't have burned down a big chunk of the forest. Now, there are cases that would mitigate responsibility. So, to use kind of a silly example, if someone could show, perhaps like with some sort of weird traffic camera, that they tossed their cigarette butt out of their car, it landed by the bush, but then someone came along and saw it and poured gasoline on it, then that would mitigate their responsibility. Again, kind of a silly case. Now, in some cases, coincidence might intervene and mitigate as well. So, for example, one person punches another, that person runs away, and then by pure chance, the tree falls on them. Now, it's true that but for the punch, the person would not have run away, but probably, one must always say, it depends. Sally is probably not responsible for his death. I mean, it's true, but for the punch, he wouldn't have run away. But of course, Sally is not responsible for the tree. Now, of course, if Sally had pre-cut the tree, punched him knowing that he'd run into it, and then triggered to fall on him, then yes, things would be rather different. So that is a very brief and not very technical look at causation in the law. If you want to see more, of course, law school would be a good place to learn that stuff. So that takes us to the end of our ventures in Chapter 3. In our next class, we'll begin taking a look at the final part of the class, looking at deductive logic.